they know exactly what to do. On our program today, we're going to talk about a number of issues that have a direct impact on the tenant community. One is the Rental Act, which we're not happy about, but nevertheless, it's here. And we believe it's important that the tenant community understand what the Rental Act means in terms of TOPA. Because TOPA rights were expunged in a sense for properties that were 15 years old. In addition, the staff will talk about some federal regulations, and we have guests today, and I'm very, very pleased that the DC Housing Authority has joined us today to talk about federal regulations that impact tenants that receive vouchers and live in public housing because the federal government has made some draconian changes to the way subsidy works in America. And we believe that it is very, very important for information for individuals who receive a Section 8 voucher or live in a property with a project-based Section 8 or receive any kind of subsidized housing, that you understand the rules of engagement have changed. And as I say all of the time, if you don't know the rules, you can't play the game. And it's very, very true. So we are very, very anxious to make sure that the tenants become extremely educated in the changes that have been proposed. Let me make sure that I say that correctly. They are proposed changes. They have not been voted on by Congress yet. But we know in the Congress that we're dealing with, the conservative swing that's going on, there's a possibility that changes could occur. But however, we are hopefully encouraged that there may be more funding for housing down the road, because it does appear that people understand that affordability is an issue for the entire nation. And with that, I'd like to now bring up Cristobal from my staff, who is Director of Outreach and Education, to provide some announcements. He and Nicole will be joining you also. So with that, please.
Hi, good afternoon all. Thank you for joining us for our stakeholder meeting. I'm the Education and Outreach Coordinator for the office. We're a team of 4 individuals. I really have 2 announcements to make. The first one is that the Department of Energy and the Environment's Low-Income Home Energy Assistance Program is still open. LIHEAP assists income-eligible district households with heating and cooling energy costs. Eligible households may receive energy bill assistance between $200 to $1,800 a month as a one-time regular energy assistance benefit. Tenants may call for more information to 202-535-2600 or apply for it on the DOE website. The next announcement that I have on behalf of the office is that well, every month our office receives approximately 800 to 1,000 calls for service from the tenant community here in the district. These calls range in assistance from, let's say, forming a tenant association, enforcing the right to organize, preventing evictions and just tenant displacement, getting a security deposit back and a check in a tenant's hand, right? So all of these things are how we serve the tenant community in DC. We're all public servants and we enjoy serving our neighborhoods and our communities. As the name of our office states, we're the Office of the Tenant Advocate. But in this scenario, I'm asking for you all to advocate for us, right? We have a budget hearing that's tentatively set for April 23rd, and we really request the tenant community to come out and advocate on our behalf so that we can better serve the tenant community in DC. As the date is, well, once the date is confirmed, we're going to send out an email to everyone on our listserv and instructions on how to sign up to give testimony, either written or oral. So that is the announcements for education and outreach. I'll pass it now to our legislative director, Joel.
Thank you, Cristobal. Can everybody hear me in the back? Good. So let's see. We first of all, we want to announce the Tenant Bill of Rights is now being revised. That was you all know that the Tenant Bill of Rights is a document that the council has required that the landlord attach to every lease issued in the district, and it's supposed to be updated periodically. We are still on our first version, which was published in 2015. There's one provision that is now a bit out of date regarding TOPA single-family dwelling. Other than that, everything in the TBR is accurate, but not necessarily up to date. We had pauses on projects to update the TBR because of the pandemic, when we had emergency and temporary laws governing a lot of important areas of tenant rights. And then with the Rental Act last year, which was impacted two major areas of tenant rights, the eviction law and the TOPA law. We are now getting around to resuming that project. So we have a draft of the revised TBR that's being reviewed by internal reviewers, external reviewers. We expect a new version to come out in, I guess, the end of FY26, which is going to be by the end of September. So let's see, we have first up, Joey and I are going to be, in our legislative update, are going to be covering a recap of the Rental Act, which, as the Chief Tenant Advocate mentioned. We also have two important council hearings coming up on March 26th and the 30th on utility issues, utility costs, transparency, et cetera. So, those are our two topics. I'm going to introduce Joey first to speak about the eviction portion of the changes in the eviction laws that people should know about. First, I'll say the Rental Act is Law 2680. It stands for Rebalancing Expectations Between Neighbors and Landlords, Amendment Act of 2025. It took effect on the last day of the year of 2025, December 31st. It's now the law of the land. And with that, I'll have Joey come up and talk about evictions.
All right. Hi, everybody. Thank you, Joel. So again, my name is Joey Trimboli. I'm a legislative counsel at Office of the Tenant Advocate. And right now I'll be running through some of the key provisions in the Rental Act regarding evictions. Like Joel said, this legislation became effective on December 31st. So what I'm about to tell you is now the law. And after I discuss evictions, Joel is going to go through some of the key provisions in the Rental Act regarding TOPA. And you're welcome to follow along on the handout we provided, which I think was on the table out in the hall. So I'll start with some procedural changes, first regarding eviction cases for non-payment of rent. So first, under the Rental Act, there's a shorter length of the notice to vacate for non-payment of rent. Prior to rental, a landlord was required to give a tenant 30-day notice before filing an eviction action for non-payment of rent. After the Rental Act, i.e. now, that requirement is only for a 10-day notice to vacate. And then second, regarding tenant payment of rent into the court registry while an eviction case is pending. Prior to the Rental Act, during an eviction case for non-payment of rent, the court would hold a hearing to determine how much rent the tenant must pay into the court registry. This could be less than the full amount if housing code violations were present. After the Rental Act, now, the court must require the tenant to pay the full amount from the outset of the case, or the court may consider evidence of housing code violations at the initial hearing. But otherwise, the tenant will have to pay the full amount of rent into the court registry during the case until the tenant requests a hearing to reduce that amount based on housing conditions. Next, a procedural change in all eviction cases, not just non-payment of rent. Prior to the Rental Act, where a landlord issued a defective notice to vacate or did not give the tenant a proper notice to vacate or filed a defection eviction complaint, the court was required to dismiss the eviction case. So this was sort of a check against landlords filing defective eviction claims. The case would be dismissed and the landlord would have to start over again. Now, after the Rental Act, the court has discretion to permit the landlord to correct any of those deficiencies and then allow the case to go forward without dismissing it. That discretion extends to any and all defects, even if the landlord fails to send the tenant any notice to vacate at all. And then finally, regarding evictions, we have an entirely new basis for evictions. These are often called public safety evictions. So before the Rental Act, regarding illegal acts committed on the property, a tenant could only be evicted because of an illegal act if a court first determined that the court committed the act, and then the landlord could provide the tenant with a notice to vacate and file the claim after the expiration of that notice. Now, in addition to that basis for eviction, the Rental Act adds a new crime-related basis for eviction for dangerous crimes and crimes of violence. The basis to evict is where the landlord alleges that the tenant engaged in a dangerous crime or crime of violence, as defined in a specific part of the DC code. It's on your handout. On the premises, and then in landlord and tenant court, the landlord would have to prove by a preponderance of evidence that the tenant or occupant actually committed the offense. And this basis for eviction would require only a 10-day notice to vacate rather than 30. There are a number of tenant defenses to avoid eviction, which are listed on the handout. And then finally, I'll just say, regarding this basis for eviction, the landlord must have considered all reasonable to avoid displacing the non-offending occupants. And with that, I will turn it back over to Joel to talk about the Rental Act's changes to the TOPA law.
Joey took that 45 seconds. That's not bad. That's a lot of material in a short time.
It's in the
Useful.
chat.
No, it's very useful, very.
Joel,
There's no question.
no questions. Okay, never mind.
All right, okay. So I'm gonna, how much time do I have, Cristobal?
2020, we've got another 5 minutes or so.
So this is the complicated part. I'm looking at the council now. So for TOPA, I'm gonna focus on the new exemptions. The Rental Act was drafted and enacted and debated mainly as a way to get investment back into the city because of the recent drop in investment in rental housing, and more specifically in permits for construction of new rental housing. And the philosophy behind it is that the TOPA exemptions are going to help promote that investment in the district. First, I'm going to mention a couple of things that we think are very good ideas. It was, I think, borrowed from another bill that was intended to help tenants and landlords as well through the TOPA process. The Rental Act establishes a program of qualified purchasers and tenant support providers. Both are intended to help tenants, one, through tenant support providers, navigate the TOPA process, understand their rights, and be able to meaningfully exercise their right of purchase. And then with qualified purchasers, that's a concept borrowed from the district's DOPA program, and in a sense, a DHCD TOPA fund, which has community-based organizations assist tenants with that's the tenant supported providers. And then with the qualified purchasers, that's about having certified, experienced, affordable housing developers listed as would-be purchasers or assignees to, who are going to be able to provide the type of affordable housing and the type of tenant experience with the new landlord that tenants want. And I'm also going to say that I'm going to try to move through this fairly quickly. So if you can write down your questions that pop to mind along the way, we're going to have a Q&A, as I understand it, at the end of all of the presentations. So please do write down your questions. Regarding the exemptions, I should also mention it creates a TOPA transparency portal, and that is going to replace the current system for any documents to be, TOPA documents to be filed either by the housing provider, the seller, the purchaser, or the tenants. For instance, their letter of intent to exercise their TOPA rights.
Excuse me, what did you say is going to be created? I didn't hear it.
It's called a TOPA transparency portal. We can elaborate that in the Q&A, but that essentially is going to be the main system for TOPA, the whole TOPA program. So moving on to the exemptions, I'm going to describe 5 exemptions very briefly. 3 exemptions are brand new. They're the new construction exemption, the new exemption for 2 to 4 unit accommodations, and DCHA owned properties. DCHA owned properties, I think, is pretty self-explanatory. DCHA is here to talk about other things later, so there might be questions for her about that exemption. But for new construction, actually, I'll start with 2 to 4 unit buildings. This started out as an exemption to help people who are sort of like small operators who are relying on a rental unit in a small building to build their wealth over time. And the notion was that, you know, grandma, grandpa on the verge of retiring, shouldn't be, bottlenecked in selling the property because of TOBA. So it ended up as an exemption that covers pretty much all owners of 2 to 4 unit properties, including corporate owners. The one exception is the DC corporations. So DC corporations who own 2 to 4 unit properties are still subject to TOBA. But if you are a so-called foreign corporation, which means that you are a corporation not incorporated in the district, but incorporated in any state outside of the district or internationally, you are exempt from TOBA as well. So that's a very expansive exemption from TOBA. With regard to new construction, is a new exemption that covers buildings constructed within 15 years prior to the transfer in question, before a proposed sale. But that sale is going to be exempt from TOBA if it is within 15 years of the new construction, and specifically the issuance of a certificate of occupancy. The exemption is not only prospective, meaning sales within 15 years after the enactment of the law, but also it applies to buildings that were constructed within 15 years prior to the effective date of the rental. So buildings built between 2011 and 2025 are going to be exempted from TOBA for a 15-year period. So a building built in 2011 is exempt until through 2026, essentially. I will now talk about 2 exemptions that are sort of expansions on existing TOBA exemptions. One is for the entry and exit of limited partners and equity investors. Again, that was one of the major issues that was the catalyst for the development of the Rental Act itself. Prior to the Rental Act, there was an exemption for the entry and exit of limited partners and equity partners only in the context of the low-income housing tax credit program for LIHTC. So it was clearly aimed at affordability, and actually a very specific type of affordability, the LIHTC program, which is a federal tax credit. Since the Rental Act, the exemption includes the LIHTC exemption, but it also now applies to the entry or exit of any limited partner or equity investor, regardless of LIHTC or any affordability intent. There are certain restrictions on the new exemption that they must have no more than a minority interest when combined. OTA took note that minority interest doesn't mean that it can't be a controlling interest, because a equity investor can own a very large percentage of property, 90%, 95% or more, at the outset of the project. The question really in our minds was about controlling interest and not the percentage of the vote based on financial contribution. So that is one of the one of the restrictions, as no more than a minority interest. They must make capital contributions equivalent to the fair market value of the interest acquired. So there has to be some match between the amount of dollars the investors actually putting into the project in order to qualify for the exemption. So a penny won't or a dollar won't do it. It reflects the market value of the interest. They can't acquire any additional interest in the project within the first 12 months after they've been admitted to the ownership. And that brings us to two additional transfers let's see, the transfer of interest among existing owners is based on the a court case that the OTA had filed an amicus brief on. And the court held that a transfer between interests in a partnership, meaning natural persons, individuals who generally partnership is going to be a very small operation. So did not contemplate corporate exchanges of corporate interests, but rather individual ownership interests. The council codified that as an exemption, which was we think appropriate. However, the council also expanded it to cover transfers between any existing partners, and that includes general partners and limited partners. The concept of TOPA up until now has built a wall of separation really between a general partner who has a so-called controlling interest and makes decisions about the management company, about rent increase policies, about the repair and maintenance of the building, as distinct from money investors who are limited partners or equity investors, but now are in a position, whether intentionally or not, to get a controlling interest in the property after 12 months. That's a concern because of something that is being paid attention to more nationally, which is private equity as a business model beginning to take over the ownership of buildings in different categories, beginning with single family dwellings, but we'll see what comes. And our chief tenant advocate is on this issue, and we will be letting the council know that we're monitoring it, and we'll be may have further things to say. So I think that is Joey's in my presentation. Joey, do you have anything else?
I have the
hearings. Yes. Okay. So we're bringing Joey up for the utility issue, switching subjects. Yes.
All right, hi again, everybody. I'm going to close out the legislative update portion of today's stakeholder meeting with an announcement about upcoming hearings at the council. So there are two hearings coming up regarding rental housing matters, and the theme is utility billing, as Joel mentioned. And utility billing is a hot topic at the council lately and among tenants as well. And on the second handout that we had on the table out there, we give instructions on how to view these bills, testify in person, and submit written testimony. So the first hearing is on March 26th. Oh, yes.
Is this one right here? It says upcoming DC council hearing.
Yes, that's the one. So the first hearing is on March 26th before the Committee on Transportation and the Environment. All of the bills at that hearing deal with utility billing matters. I really want to just highlight, for the sake of time, one bill in particular at that hearing, the TRUE Act, or the Transparent Rates and Utility Expenses Amendment Act. So the OTA actually drafted many provisions of that bill. It would require a number of landlord disclosures to help tenants better understand their utility bills from the landlord. It also requires the landlord to permit a tenant to inspect submetering equipment for their unit and its readings. It caps customer service or administrative fees for utility billing at $1 a month. And it prohibits filing an eviction for non-payment of utilities in an amount less than $600. And it has a number of other provisions as well. So if your landlord bills you for your utilities and you've ever felt confused or in the dark about why you're paying what you're paying, you may be interested in that bill and you may want to give your testimony. That hearing on the 26th also includes several other utility billing measures, a couple of bills that would permit tenants to take over the utility bill where the landlord fails to pay and it's subject to shut off, and to deduct those payments from the rent. Another bill would prohibit utility shutoffs during hot and cold months for certain vulnerable households. And then next, quickly, the Committee on Housing is holding a hearing on March the 30th, excuse me. That hearing will also include the TRUE Act and a couple of other rental housing measures. I would call your attention, in addition to the TRUE Act, specifically to the Portable Tenant Screening Report legislation. So of course, we know it can be very expensive to apply to apartments. You have to pay $50-some for every application. If you get rejected, you have to pay again to apply somewhere else, and then perhaps again and again. This bill would help out by permitting rental applicants to use reusable tenant screening reports instead of paying an application fee for every unit they apply to. There's other legislation listed on that handout for those two hearings. We encourage you to take a look and consider testifying. And we especially encourage you to testify regarding the TRUE Act if you've had bad experiences with landlord utility billing practices.
And our chief tenant advocate will be testifying on the 30th.
And our chief tenant advocate will be testifying on the 30th before the Committee on Housing.
You have a question?
Yes.
Are we talking about, does this also include the car service billing? Is that represent this?
That is part of the TRUE Act. There's a provision that states that basically that disputes regarding your utility bill from your landlord are between you and the landlord, so that the landlord shouldn't be foisting a third-party biller like Conservice on you to explain things to you. It also would require a lease to give the tenant the contact information for a third-party biller. Yeah.
Thank you.
You're welcome. And that's it for our legislative update. If there are no more questions, I will turn it back over.
Well, I'm not sure who you're turning it back over to. But now it is time for our guests to come up and talk about the federal proposed rules that have been put in place. I thought it was extremely important for individuals, particularly if you are a tenant association president. It is important that you know what we know about what's going on, particularly if you have tenant members of your community who are receiving a subsidy. You should be aware that there's several proposals that could be damning to your future, not necessarily right now. So I'm very, very happy that we have with us today Hammere and Nicole from the Department of the Housing Authority to talk to you about these proposals that have come forward. Ladies, would you come on up? Gentlemen, would you move? Yes. Yes,
Girls will. Yeah, the girls work.
sometime,
No.
please. Please.
Good afternoon. I've been accused of being many things, but loud is not one of them. So I'm gonna try my best. But my name is Hammere Gebreyes and I'm with the DC Housing Authority. It's a pleasure to be here with you. Thank you guys for inviting us because it's actually very informative for us too to hear the analysis and the hard work that you guys have been doing. So thank you so much. As Director Shreve said, we have been invited here to give you an update on some of the proposed changes, and I have Nicole Barrett here with me, who is our MTW Director Policy. So she's very, very, very experienced with on the federal side and has been following federal regs and the policies very closely. But we also wanted this to be an opportunity to just share some updates. I wasn't sure of who was in the room and what questions you may have, so we have some very general updates as well. And we'll also be able to answer any questions as they come up. So without further ado, I'll turn it over to you, Nicole.
I think we can go to the next slide.
One more.
Okay.
Yeah.
Perfect.
Thank you. Again, my name's Nicole. I am the Director of Policy and the MTW program at DCHA. I've been with the agency for about 1.5 years. So thank you for having me here today and Hammere as well. I wanted to talk about 3 rules that HUD has proposed in the past couple of weeks. I'm just gonna walk through what those rules are about, what's contained in those rules, and then also talk a little bit about the public comment process, because as has been mentioned, these rules are currently proposed. They are out for public comment. And so the first rule is, the name of it is establishing flexibility for implementation of work requirements and term limits. Again, this is a proposed rule. The comment period ends on May 1st. What this rule would do is amend current HUD regulations and provide public housing authorities and also certain multifamily owners, namely those who work with the project-based rental assistance program. It would provide them the option to implement work requirements for essentially work-eligible adults. It would also provide them the option to implement term limits specifically for residents who are non-elderly or non-disabled. So this could potentially apply to families receiving assistance through the public housing program, through housing choice vouchers, through project-based vouchers, or those who are in buildings where there is project-based rental assistance. The rule contains some mandatory requirements like hardship policies. Again, it can't apply to certain households depending on their demographic, but it also would provide a housing authority or these multifamily owners some flexibility in determining the policies as well. For example, a housing authority could decide, whether or not they want to target different programs, or how many hours they would want to set as far as a work requirement. So that is the first rule. Again, it is currently proposed. It is not final yet. The second rule is around the verification of status related to immigration status. So the name of it is Housing and Community Development Act of 1980, verification of eligible status. So what this rule would do would revise some of the regulations that HUD currently has and require a tightening of the verification of either U.S. citizenship or other eligible immigration statuses for all applicants and recipients of certain housing assistance programs. For example, public housing, the Housing Choice Voucher Program. That is the first thing that the rule would do. The second thing would be related to what's called the proration of rent. So this primarily would affect what are called mixed status families. A mixed status family is one in which at least one member of the household is eligible for HUD assistance based on their citizenship or immigration status, and at least one other member is not. Currently, the rule that HUD has says that you can prorate the rent for those mixed status families. So if you have a household with 4 people, 3 people have eligible status, 1 person does not, the rental assistance only covers 3 people. What HUD is proposing is instead making that proration of rent temporary while eligibility is being verified for in all members of the household, instead of what it currently is, which is on a more permanent basis. And then the final rule is the revocation of the 30-day notification requirement prior to, I know these are all kind of lengthy in their titles, prior to termination of lease for non-payment of rent. So this is around, what are the notification requirements if there, is non-payment of rent and there's an eviction action at play. So what this proposed rule would do was revoke what the current requirement is, that PHAs and also owners of project-based rental assistance properties provide 30-day notice prior to terminating the lease, specifically for non-payment of rent. This actually reverts back to basically pre-pandemic era policies. And so what it really does is instead of a standard across everyone, it now reverts back to, what are the individual program regulations, what are state regulations. So now it can kind of vary depending on the location and the program. So those are the 3 rules that are currently out for public comment. So if you have thoughts and opinions on these rules, one thing that you can do is you can weigh in through HUD's public comment process. There is the opportunity to either submit comments electronically or by mail. And on the slide, we included just a little bit of information about where you can find that process. I will just say, having experience in the federal policy space for a number of years now, HUD does look at the number of comments that are submitted for these various rules that they put out. It's also important that folks submit different comments. There's often sort of filters on especially the electronic submission process. And so, if you're sending all, comments that are all the same, HUD might only count them as one. But if you're, saying, hey, this is how I feel as an individual, HUD's going to consider that as a separate comment. So definitely open to taking questions about these rules or the public comment process, but I want to be mindful of time. And so I'll turn it back over to Hammere to just give some general updates about DCHA.
Thank you, Nicole. And as Nicole said, one of the things that they do look at is, like sometimes there's a letter writing campaign and everybody submits the same letter. That's going to be counted as one. So you want to be able to, if you are so moved as to submit comments, is just individualize them a little bit more. But there is an option to send it by mail or electronically. So, agency, as many of you know, has public housing, operates a voucher program. We have a very robust, both federally funded and a local program. So I invite you to visit, and I think we can circulate this electronically as well so that you can activate the link. But if you also go to our website, the impact report, which actually has a lot of information about some of the improvements and activities that have happened over the last couple of years, will be there. But to highlight, it includes an increase in the public housing occupancy rate, additional vouchers that are in additional utilization. So we have increased our utilization for both the federally and locally funded voucher programs. We have been continuing to modernize and repair our public housing communities. We are also, we have our Office of Resident Services that also works on workforce development opportunities. And so there's been quite a bit of activity there as well. So it's, I didn't want to take up all of your time here at this session, but know that this information is available on our website. And then one of the operationally, I would say one of the more significant things that we're implementing, and we can go to the next slide, is the expanded features in Rent Cafe. So Rent Cafe is the system of record. So it's Yardi Voyager system that we're using. And this is for applicants, voucher program participants, as well as residents in public housing. And I would say it was maybe about 3 years ago, where we turned on Rent Cafe. So applicants, voucher participants, and residents were encouraged to register. At that time, all you had really was viewing access. So you could see your information, but you still had to, submit a form if you're updating your information on the waiting list, or recertifications would, you'd have to come in, snail mail, drop off. That there's just inefficient ways, and some of it was exacerbated by COVID, and when we had to go to remote, then there were emails were going in, people are dropping off, some things are being scanned. It was a lot of opportunities for things to get lost or to get lost in the shuffle. So one of the things that I think will make life a lot easier all around is that now you can actually update application information directly in Rent Cafe. We've now launched where you can do recertification. So for folks that are in the voucher program or in public housing, where they can actually submit information directly into the system. And same for landlords, that we're able to have ways for them to view information more directly. There's a bit more visibility now. We also recognize that not everybody has access to computers, and it is a learning curve. So our offices also have computer banks so that people who do come in can get assistance, but this is a way to help make information more readily available. And speaking of our offices, we do have 3 locations. Unfortunately, we have one, our main office, actually. This is where our voucher program, most of our staff is, as of Friday, this past Friday, was temporarily closed. And so the building owners are working with the Department of Buildings to address some of the issues that were identified when there was a recent inspection. So we are hoping that we'll reopen because that's where the bulk of our voucher program participants do go. But in order to keep activity moving, we still do have our 2 satellite offices. One is 625 D Street, which is right in Southwest, where our administrative headquarters are. So you can still come in there, or to Alabama Avenue address. But what we also do is encourage folks to call the 535-1000 number. So if you have an appointment already or want to make an appointment, but calling will also, a lot of times our call center staff can actually access information and might be able to help with addressing whatever the questions are, even so you don't necessarily even have to come in. So we just wanted to let you know that, and I'll turn back over to the OTA folks, and we can certainly answer any questions that may come up.
Are there any questions in the room?
Yes. Let me introduce myself.
Yes, please.
Good afternoon, everyone. My name is Venus Little. I am the president of my tenant association, the Tyler House Apartments. And I serve on different boards throughout the District of Columbia. One is the Coalition, and Manor as well. I have a question here about the Rent Cafe. The Rent Cafe, the part that you said folks can self
You can submit
update their
directly.
information, is that due to new applicants as well?
So that's a great question. We are, right now, the waiting list is not open to new applicants.
Okay,
So-
so when I say new applicants, I'm sorry.
For
I
someone
used
on
it
the
wrong.
waiting list.
Someone who already have,
who's
who's
on the-
waiting for their voucher to come on, to come up. They already been received a notice, so they just waiting to hear back from. So that, the cafe is for folks like that as well?
Yes.
Okay,
But you can also call 535-1000, and I believe our website also has the update form if you wanted to fill it out.
so if someone went to the office on 7th Street, on 8th Street, which is now closed, the staff there should have been directing or addressing those folks to use the Rent Cafe or not? Should they, or?
They're doing so more and more now. Yes, so depending on when you were there. But if you come in person and you provide your information, they might just take it and put the information in as well. So I think they're trying to, it's just giving you opportunities to, whether it's in person or not.
I'm sending you another email about a situation.
Sure.
Instead of talking about the situation, person just did that in January. They told him that they sent him a notice about his situation in December and his voucher.
Yeah, so
I would,
if there are individual questions, I think I can maybe put my email in the chat. But I'm happy to take that information directly and then we can follow up.
my other, no, my, other question is, how is HUD holding, agencies, project-based public housing, folks, not just accountable, but how they overseeing or looking how folks address folks for the workforce, and then the, I wrote it down. Project-based for the agencies who folks who, I guess,
No, I
they do
think,
their dirty work to, to put folks out on the street if they're, holding, I guess, immigrants,
yeah, so
folks that's not
I
on
think-
the lease. How are they catching up
I
with
think
that?
this
How are
may
they
be,
monitoring?
a more difficult one for us to answer, because I think there are, as we mentioned, some of these proposed changes are not just for housing authorities, but for privately owned properties that are under the project-based
Yes,
rental assistance program. It's different parts of HUD. So there's the HUD that oversees the public housing and voucher programs, and there's a different part of HUD that oversees the project-based
Thanks.
rental assistance.
And there's nothing in the rule that's proposed that would require like housing authorities like DCHA, for example, to conduct immigration enforcement actions.
Okay.
Yeah, that's not part of what the rule is saying. It is putting more verification requirements on it, and it is changing that proration of rent. So, that comes through just normal eligibility verification. That would be something there's, but there's nothing in the rule that would require like an immigration enforcement. Just whether or not this household qualifies for housing assistance.
okay, and they don't have to make a choice to house their family or them be, unhoused themselves. Immigration status.
I mean, yeah.
Okay.
There's a question in the back.
Oh, hi. Yeah, really quick. I'm Jack Slatter with VOTA. In this push for use with Rent Cafe, does Rent Cafe include per tenant maybe something like a document bank? I have a lot of clients who find themselves needing access to their old recertification documentation or their HAB contracts or documentation of the payments that have been being made to their landlord over time. And a lot of them really struggle with getting access to those kinds of documents. Are those something that's going to be available in Rent Cafe?
No, that's a great question. And I can circle back with more specifics on what things are readily available versus what things do you have to request and it gets provided.
Would you be able to request them through Rent Cafe?
There
Excuse me.
there is a feature kind of like a ticket system where you can send the request, but right now it's a record request at dchousing.org for anyone, whether it's an advocate or a participant or person themselves who are requesting records. There's an email, it's, I believe, record request. I'll double check it on my phone where there's an S or not at the end of it, but you can submit a request for records and it would be provided.
Great, thank you.
Hammere, can I ask you a question about in particular, the recertification aspect? Because we have begun to receive a lot of complaints from properties with older tenants where the housing provider is forcing the issue about recertification, and where prior to the Rent Cafe or whatever, these tenants were able to provide their recertification documents in hand to the management company. Now they're being told it has to go through a rent portal. So when the housing authority decided to move to that genre of utilization, did they require the housing providers to provide training to the tenants? Because a lot of these tenants they're not computer savvy. They don't have cell phones. They don't know how to use the system, and they are the seniors are being frightened and even told that they're going to lose their apartments because they haven't recertified. So is there something that the housing authority can do to encourage the housing providers who are involved, the management companies, to provide training to the tenants to help them ease in so that there's a transition from hard copy materials to the electronic format that both HUD and the housing authorities are trying to achieve now for record keeping purposes?
No, I think that is a great question. And it also brings up, there's a dynamic too, where there are more and more properties that might have tax credit. So there's the subsidy that they're getting from the housing authority, but it may also be a tax credit property where they actually do have to do recertifications. So there's different layers of recertification, which might also cause some confusion, because for the rental assistance in the voucher program, the recertification requirement, unless you have a change that you want to tell us at any point, is every 2 years. But I believe there's also a tax credit recertification requirement for the properties that have tax credits that would be every year, and which is a different.
I understand what you're saying about that.
And so where the property management might be involved is probably on the tax credit.
Well, Edgewood is one of the properties that we're getting a lot of,
Right.
I get a lot of complaints from the tenants at Edgewood.
And maybe we
Enterprise is
can do a
managing that.
cross-check. Yeah,
Huh?
maybe we can do a cross-check of particular cases so we can see where it might be connected to DCHA or not, so that we can.
Yeah, because most of these have not talked about LIHTC as being the issue. It's just been the recertification side. We had one the other day where the tenant receives a Section 8 housing choice voucher. She has a mental issue. So I'm wondering, do you sub-recipient out vouchers to, behavior health and other places where they're actually administering the voucher? They're the ones, you guys are sending the vouchers to them. They're the ones giving the voucher to eligible tenants who may not have capacity. And in this particular complaint that I got, because I got it on Sunday, the tenant had received termination of her voucher, although it had gone in for appeal process. So we're still trying to sort through all of the finites on this particular case. But what I'm saying is I'm seeing a rise in anxiety, frustration from the tenant community on the side of the recertification process. And so I didn't know where that.
Which there are some voucher allocations, both federal and local, that are targeted to specific target populations.
Right.
So more so on the local side, because we have a tremendous amount of funding that has been allocated for referrals from the Department of Human Services for PSH, so permanent supportive housing, and what we call targeted affordable housing. So in the cases where it might be a target population or someone that's receiving, that's also connected to DBH or DHS, there may be case management where they're supporting them in completing their research or even their eligibility from the beginning. So it may be that the properties, because what happens is if you don't recertify, then you're in danger of losing your assistant.
Understood.
So there's an interest in the property to make sure that your recertification is completed so that we can get to the next. And so it may be that it's an interplay between the two, so that there's case management that's supporting the household in keeping up with their obligations, but property management is also maybe stepping in. So
Right.
that might be the dynamic, because there has been over the last few years a significant amount of new funding locally for target populations that are tied to case management.
Well, it would be helpful for me if staff on our side could have conversation with staff on your side, because a lot of the times when we get those kinds of calls, we really need to be talking to you guys, you know what I'm saying, about the specifics on it, because sometimes it's really an intimate situation as to whether or not the individual's going to lose housing. And so I think establishing that kind of relationship would be helpful.
We have one question we'd like to get from the
Yeah,
chat.
there's one question in the chat, and then I think we have to move on to our next presenter. So the question was, how long is the waiting list open or closed for senior buildings, and where can we find that list?
So right now, none of our waiting lists are open and taking new applicants. We are closer to getting to a stage on the public housing side where we may reopen. I don't have a specific time frame right now, but for the housing that's connected to DCHA, we have both a public housing and a voucher one, and neither are open at this time.
Thank you so much. We really appreciate all that information.
Thank you so much to our colleagues from the DC Housing Authority. So now we're going to have someone, Ms. Kebede from the DC Board of Elections,
Need some help with
explain
that?
Yes,
ranked
please.
choice
Yeah.
voting.
Your staff can help you.
Good afternoon, everyone.
Good afternoon.
Thank you all for having me here today. I am Yewoinhareg, and I'm a public affairs specialist with the DC Board of Elections. Today, I'm here to talk a little bit about ranked choice voting, why we got here, and specifically about how it will be implemented here in DC. I think it's
Yeah.
something, yeah. In the meantime, as mentioned, so I'm here to talk about ranked choice voting, which is the new voting system that will be implemented in DC, starting with the June primary elections. And that is because DC voters voted to support that during the general election with Initiative 83, which part of that advocated for the implementation of ranked choice voting. So because of that, the DC Council voted to ranked choice voting and actually funded it for the fiscal year 2026 budget with the implementation and rollout beginning in the June primary election. So we at the board are tasked with implementing this and ensuring that DC voters, residents are educated about this new voting system because DC residents voted to approve it in the general election in 2024. So these are the list of contests that ranked choice voting will be subject to. As you can see, it starts all the way up to the president and vice president contest and all the way down to the advisory neighborhood commissioners. So the only exception are the state party or the local party elections. Those will not be subject to ranked choice voting, but every other contest listed here will, so long as there are 3 or more candidates running in that specific contest. So now about what ranked choice voting is and how it will specifically work in DC. So there are many models of ranked choice voting. Different jurisdictions have different restrictions and just regulations for what ranked choice voting will look like. In DC, the regulations and the legislation was approved by the proponents of Initiative 83. So they were the ones responsible for writing the legislation. So according to that is what the board is tasked with implementing. So we at the board did not have a say in that. But in regards to what RCV will look like specifically with board elections, as mentioned, all the contests listed in the previous slide will be subject to ranked choice voting, so long as there are 3 or more candidates within that specific contest. And you can rank up to 5 candidates. So there might be more than 5 candidates within a specific contest, but the voter is allowed to rank up to 5. and ballots are counted. So if the first choice of a candidate is not reach majority of the votes, then we go into subsequent rounds. So before I talk about more the tabulation and how we go round from round, I do want to talk about how to properly mark your ballot. So this is what a sample RCV ballot looks like, and you all should have received that as well. The candidates for the purposes of this are, cartoon characters because this is just a sample, but the contests are what will appear in the June primary election. So the biggest thing is one column, one row is what we're telling voters in terms of to ensure that you're only completing one vote per column and per row. As mentioned, you can rank up to 5 candidates. So you'll see that you have your first, second, third, fourth, and fifth choice, and then the candidates follow down below. Voters are not required to rank. We do want to point that out, but it is the new voting system. So we encourage voters to exercise their full voting right. But you are also more than welcome to just select one candidate and proceed prior to ranked choice voting being implemented here in the district. So if you could press it a few more times, there's and this is just a demonstration of how to accurately fill your ballot so that it can actually count. So as you can see, this person has ensured that they've only selected one candidate per column and per row. And so this would be a great way of completing your ballot. I think it likes the visual. And the visual will help because the next step, I'll be talking about some mistakes to avoid.
Going back to 5, sorry.
No worries. Perfect, okay. So as mentioned, we do also want to caution some mistakes to avoid. So the first one being giving multiple rankings to the same candidate. So as you can see, the ballot to the left, this voter has selected Donald Duck for their first, second, and third choice option. So this does not benefit the candidate in any way, shape, or form because you have one vote. And those votes only get transferred to your next choice candidate if your first choice candidate is eliminated. Now, you might be wondering how a candidate is eliminated. That's if during the first round, a candidate does not reach that 50% plus 1 threshold. The candidate with the fewest number of votes is then eliminated, and their votes are now transferred to the voter's next choice candidate. So when that happens, Donald Duck, in this case, if Donald Duck were to be eliminated because he received the fewest number of votes, this voters contest will no longer be valid because they've selected Donald Duck for their first, second, and third choice. And their vote can no longer get transferred to another candidate because they've only selected Donald Duck for all of their rankings. So in this case, at the point of the second choice, this contest will become inactive, meaning the vote stays with Donald Duck, and because he is eliminated, that's the extent to which the contest moves for that specific voter. And then now to my right, another mistake is giving the same ranking to multiple candidates. So we cannot interpret voter intent, meaning if you select more than one person, that also makes your ballot or your contest inactive. So in this case, the voter selected Beyonce as their first choice. If Beyonce were to get eliminated in any round and we were to go into a subsequent round of voting, their vote will not get transferred to their next choice candidate because this voter has selected 2 candidates for their second choice. And so at the point of the second choice, their contest will also become inactive. And I do want to point out, when I mean contest, it's that specific office. So it doesn't invalidate the entire ballot, but that specific contest. Next slide. So another mistake, and this is just a mistake, it does not count or render your contest as invalid, is skipping one ranking. So in this case, the voter skipped their second choice, but they ranked their first, their third, and their fourth. So this is only a mistake in relation to the ranked choice voting legislation. The way that the proponents wrote the legislation, it allows for one skip. So in this case, what will happen is if Beyonce, the voter's first choice, is eliminated, their vote will actually get transferred to Donald Duck, which is their next choice candidate. And even though Donald Duck is their third choice, it will count as their second choice candidate, and everything just moves over one because one skip is allowed with the regulation. And so as you can see, that skip does not invalidate that contest. But in this new ballot right here to my right, this voter has skipped their first and their second choice ranking. So according to the legislation, voters cannot skip two subsequent rankings. That will render your contest invalid. And so at the point of the second skip, your contest will become invalid. And because in this case, the voters skipped their first and their second, they will not have a vote counted for this specific contest or office. In this case, they went straight to their third choice ranking, but this will not count because they've skipped their first and their second. But if a voter had selected a person or candidate for their first choice and then they did not rank a second and third choice, but they ranked their fourth choice, their first choice candidate will get the vote. If that first choice candidate is eliminated, then their contest will be rendered invalid because of that two consecutive skips of rankings 2 and 3. And so all the red just shows the point at which your contest becomes invalid in this case. And then next, I'll be talking about the tabulation, and this is how we determine if we move into subsequent rounds of voting and just a visual of how votes will get transferred from one candidate to another until we're able to determine a winner. In the meantime, I can take questions from the first half of my presentation. If there's any, please feel free to ask. Okay. So in this round, in this case, there are 4 candidates. So candidates A, B, C, and D, and the circles represent votes for them. So in the first round, there isn't a candidate that has surpassed that 50% threshold. And so we are able to go into a second round of voting. In this case, because candidate C has received the fewest number of votes at 3, they will get eliminated and will go into a round 2 in which the votes for candidate C are now transferred over to the voter's next choice candidate. So in the second round, there still isn't a candidate that has surpassed that 50% threshold. We're eliminating candidate D this time around because they've received the fewest number of votes. And when candidate D is eliminated and their votes are now transferred to the remaining candidates and the voter's next choice, we have candidate B who has reached that 50% threshold. So at round 3 is when the tabulation ends for this specific contest, and candidate B would be declared the winner in this case. Now, the difference I want to point out from the voting system prior to ranked choice voting is, 1, we would not have rounds of tabulation, and candidate A would be projected as the winner because they received the most number of votes. But because of ranked choice voting, it's not about the candidate who receives the most number of votes. It's about the candidate that receives a majority of the votes. Hence why we go into subsequent rounds until one candidate does reach that majority threshold.
Did they provide us with a copy of the tabulation results of this?
Good question. So our FAQs, which you also should have, outlines that tabulation process. But we do have this presentation that we're we can send along for you all to have access to a copy of it as well. But on our webpage, if you just go to dcboe.org/RCV, there is an interactive simulation where you can vote for your favorite ice cream flavor. And then you can see that live tabulation. Yes, there's over like 10 flavors on there. And you can see the live tabulation of the votes actually being transferred from one ice cream flavor to another.
So just go to the website. Okay.
Yes, ma'am, exactly. And now we do want to level set some expectations ahead of the primary elections with this new voting system. We do want to recognize that voting will take a lot longer. So we do just ask that you come with patience. Our ballots are long. There's a lot of contests on the ballot, as well as a lot of candidates for running for a majority of these offices. So it will take a lot longer than what we're used to. But we do want to ensure that everyone that goes to vote will be able to vote, and that there will be adequate guidance on ranked choice voting at our vote centers. We'll have trained site coordinators who are able to answer any questions in regards to this new voting system. And every DC resident actually receives a mail-in ballot, and those will also outline detailed instructions on how to completely and accurately fill your ballot, as well as have a visual on what to do and what not to do, similar to what we had earlier in my presentation. Voters also have the opportunity to bring in their mail ballots in person to a vote center and also receive assistance that way. And you can drop off your mail ballots at a vote center as well. So you all might have started receiving some mail circulation about ranked choice voting. Those palm cards that I've passed out also should have hit the mail stream, and we plan on sending out 2 more mailers between now and the June primary election so that residents are informed and are aware of it. Along with that, we have our webpage, as I mentioned earlier, where you can find more information and the FAQs, along with our elections calendar, which outlines important dates and deadlines as we head into the primary election, along with deadlines, results, and everything in between. So now I'll shift gears to results. So results will look a bit different, but still similar in the sense that preliminary results will still be released on election night, which is what we've done in previous elections. The only difference is we're not sure of the schedule in which we'll release results. So we do have 10 days to receive mail ballots so long as they are postmarked by election day. And we're currently deciding if we're going to do the tabulation as we receive votes and ballots, or if we're going to wait until that 10-day period to tabulate everything all at once. So once we've decided, we will ensure that we put out messaging that confirms the route that DCBOE will take in regards to results reporting. But I do want to stress that as we do various rounds of tabulation, those results will be available as the tabulation results are produced. And so we're going to be open and transparent in terms of the results process, whether, it takes us 10 days after or so in terms of the deadline to certify the election, we're still figuring out. But everyone will know the results as we have them, as we go along.
I suggest as received.
Next slide, please. And so this is our DCBOE events calendar, which is housed on our website. This outlines all the events that we do across the city in terms of ranked choice voting. It has the date, the time, and the address, because a lot of folks ask us what we're doing in the community. So all of this information is available to the public on our website. If you all want to just take a moment and take a look at some of the places that we've been or we have. Our schedules are pretty filled up for March, April, as well as the scheduling all the way up until the end of May, prior to the start of the primaries in June. Next slide. Okay, and then this slide outlines some other materials that we have in regards to ranked choice voting information. So as mentioned, we do have a webpage for ranked choice voting on our website, which is at dcboe.org/RCV. These have our FAQs as well as that live sample ballot of choosing your favorite ice cream flavor, and you're able to see the live tabulation results on there. We do also have an in-person resource lab at our office, which is located on 1015 Half Street Southeast. So this is a room with voting equipment as well as sample ballots like some that you have today, along with information on ranked choice voting that is open to the public. Anyone can come in and they can experience voting live with ranked choice voting on our voting machines, as well as get any questions answered by a member of the board. So there is that live one-on-one demonstration. As mentioned, we have our FAQs, which are both on our website, and we do bring to various outreach events such as this. We have palm cards, which have started circulating in the mail, as well as circulating through outreach events such as this. And we do numerous in-person, virtual and speaking engagements at high schools, colleges, senior residences. And we just want to ensure that we reach every DC resident where they are and have multiple touch points throughout the community prior to that June election. So in terms of what we have coming out soon, that election tabulation simulator is already live in our website, as mentioned. We have an explanation video that should be coming out and circulating. We will have a voter guide, and as mentioned, we still have 2 more mailers in regards to ranked choice voting that will come out between now and June as well. Next slide. So we also have a dedicated email for questions regarding ranked choice voting, and that's just at rcv@dcboe.org. We welcome any questions and a member of our team answers them, as well as if you're interested in an outreach ranked choice voting workshop or presentation similar to the one today, we do have our outreach email, which is just outreach@dcboe.org, in which we take requests, and we're taking a request up until the end of May to be able to come out to the community and engage with residents. So that concludes my presentation. I do want to take a moment and ask if there are any questions.
A few questions in the chat.
Sure.
One is, how do you sign up to work the polls and when does training start?
Yes, great question. So you can find our application on our website, dcboe.org. There's an election workers tab, and you're able to submit the application that way. And you can either email it to us, come in person at our office, and training has already begun for election workers. So we've started contacting our election workers because there is a mandatory 4-hour training prior to serving as an election worker. But we do actively recruit for election workers throughout all parts of the year, regardless of not if it's an election year or not. So we're always in recruitment.
And then another question is, will a voter be told that their ballot has a problem when submitting it for counting or scanning?
Okay, great question. So no, it is up to the voter to double check their ballot and determine if they've missed anything, or if, we do recognize that this will take some time, even with the voting machines. You have the opportunity and the ability to review all your ballots, all your votes at the end prior to printing your ballot. But there isn't a system or a notification that will get flagged if you skip a ranking, because we do allow skips, and folks are able to still just select one candidate. So there's no official notification for a skipped ballot. The one thing I will say for the voting machine, so you can only select one candidate per contest. The machine does not allow you to make 2 selections. So if you select a candidate and then you try to select a second candidate, it'll automatically deselect your first candidate and it'll select your second candidate for you. And then you can review at the end, and you can go back to that specific contest should you wish to change that. But in regards to the paper ballot, it's the same as before. It's up to the voter to review their ballot. And, we understand that mistakes do happen. So if there is a mistake, we ask the voter to alert the person at the vote center, and we can issue a new ballot. We'll spoil that ballot to ensure that it doesn't get counted, and we separate it from everything else in a special spoiled ballot envelope, and we're able to print out a new ballot right then and there, and so the voter is able to vote as is.
And then another question, if I think I'm reading it right, is there a phone number to have you or someone else come out to speak, like a speaking engagement?
Yeah, so I can share my email with you as well. We also take inquiries through our general outreach email, which is just outreach@dcboe.org.
But just the email, not a phone number.
Yes, and we also have our phone number on our website, and I'll provide my phone number as well if that works.
Any other questions in the room?
Are you taking any requests today?
Yes, ma'am, I can. I also have some business cards as well.
Great, thank you.
Thank you. Thank you. If you can put it on short notice too.
And so I promised that we would get to the last questions at the end that were mostly for our policy team. So we're gonna grill you, Joel and Joey. You wanna come on up? And these are questions from the chat. Thanks, guys. So does the new Act for utility bills allow for tenants to get detailed information and underlying bills? I heard that building management must provide information and access to sub-meters, but does the Act as written or as proposed provide full access for analysis?
Did everyone hear that question?
No.
So, yeah, I think this question is about the TRUE Act, which is the utility billing legislation that OTA did a lot of work on. It's going to be the subject of both hearings, both the hearing on the 26th and the 30th that I mentioned earlier. So the answer to all of those, I think, is yes. Could you repeat what were the?
Yeah, I heard building management must provide information and access to sub-meters, but does the Act as written or as proposed provide full access for analysis? So underlying
Yeah.
bills too. things like
So the legislation does, and to be clear, this is legislation that is not law yet. It's just being considered at the council. There's a hearing coming up, 2 hearings. But this bill would require a landlord to permit the tenant to inspect sub-metering equipment for their unit, to do so with a private inspector if they wish, and to check the meter readings on the sub-meter. And I think the question also asked about the landlord's overall bill for the property, the underlying bill.
that. Right,
call it,
yeah.
and information about how the tenant's utility bill is calculated. The landlord would be required to provide all of that to the tenant under the TRUE Act.
Including the copy of the bill received by the landlord from the utility, not just the landlord bill to the tenant.
Right, including the landlord's bill from the utility provider for the property. So the tenant can apply the formula for calculating their unit's bill to that overall bill for the property and check it against what they've been billed by the landlord.
And you were, how about the RUBS? What did you mention? RUBS.
So in many of these scenarios, the landlord is using what's called RUBS. It's the ratio utility billing system. This is where, so the landlord gets one bill for the whole property from the utility provider, let's just say Pepco, and then uses a mathematical formula to divide that bill among the units. There might be factors like unit size. It could be the number of people in the unit.
Empty units.
Sure, sometimes people are charged for the usage of vacant units. That's addressed by the bill as well. And common areas as well. So RUBS scenarios are going to be generally the kinds of scenarios this bill is applying to. Although, like I said, it would allow the tenant to inspect a sub-meter as well. And
Okay,
covers
and then a little bit more. So are there any applicable provisions in either the new rental act or in this upcoming legislation that would force owners of non-rent controlled or public housing to force timely repair and maintenance of building amenities and services, or security is also an issue? Is there any standard or standards board review? And is there a provision to keep records of complaints by tenants against landlords online or public after they're resolved? Like how DOB closes out their online dashboard.
I think that's it.
Resolved.
Yeah, so the Rental Act does not address those things.
I think that question is for DCHA, it's not for the portal. It sound like, cause
That was a.
I think it was more for you guys, actually. Yeah, it was more about the legislation. Yeah.
Questions?
So I think Joey answered it. The Rental Act does not change increase or decrease any requirement that the landlord now has to make timely repairs, or to require a DOB to, I guess, better record whether there's been an inspection request, whether there's been a notice of infraction, whether the violation has been abated. But so I'm not sure if the question is about a particular situation or about which it could be, or if it's about any change in the current rules regulating the inspection and infraction, and then when the case is closed out because the problem has been abated. All of that is searchable. OTA uses the databases that DOB has about those issues, all the time, and they're generally publicly accessible as well. And if folks have questions about this, they can contact us. Explain that.
And then one more from the chat. And are there any provisions for tenants who are in 2 to 4 unit buildings under the new TOPA laws?
What is the question?
Like, are there any protections for 2 to 4 unit tenants?
Well, I think I saw the.
You have to read it out to the audience.
It said, are there any protections for tenants who are in 2 to 4 unit buildings to secure housing under the new TOPA laws?
So what that question might be coming from is the fact that the 2 to 4 exemption is now very, very expansive. There is no TOPA for tenants in 2 to 4 unit accommodations unless the ownership is a DC corporation. So that's the rule. However, that doesn't mean the questioner might be thinking, oh, well, then the tenants in the 2 to 4 unit accommodations are going to lose their housing. Might be where that's coming from. If they're wondering how are we going to get help securing other housing? So very important to underscore. The TOPA is a part of a law called the DC Conversion and Sales Act. The conversion does impact or can impact whether the tenant's housing continues, because that's about a conversion from a rental accommodation to a condominium or cooperative. And once that ownership changes, tenants can be evicted unless they become essentially owners or a renter of an individual owner. But for TOPA, there is no impact on the right of the tenant to stay in that building, subject to the same lease, subject to the same terms in that lease, unless the tenant agrees to change the lease terms and the bases for eviction are exactly the same. Pay the rent, or the landlord has some other reason to, like discontinuance of housing use or et cetera. It's all the same basis for eviction. So if the questioner wants to clarify, I hope that answers the question. There's going to be no displacement because the TOPA right went away. It's an important right, and we're not thrilled, like as the chief tenant advocate said, that those rights went away. But it should not affect the housing itself.
So on that note, Jordan, I know we kind of had this conversation. I'm Jermaine Leftwich.
Oh, hi.
How
Ms.
are you?
Leftwich.
I've been trying
Thank
to
you for-
dissect all of this.
That was a very helpful situation you gave us, which we did share with the committee.
And what I'm kind of still, even in the lease, in my lease, under the TOPA exemption clause, it says that it is now exempted from the act, but it's not. They're making this rental act sound like TOPA is totally exempted, but like as the mayor referenced in her article and as everybody else referencing here today, once the property turns 15 years old from the date of construction or opening or whatever, that then you are subject to TOPA. You could use your TOPA rights.
Exactly.
But this paragraph is not saying that. It's saying that we are exempt from TOPA. This is a discrepancy that I'm having still. Yeah. I've waited for 2 weeks. I suggested to the property management team to submit our comments, so to speak, to their attorneys. I've yet to receive anything back from them.
Okay.
And I appreciate the fact that, the DC Bill of Rights is gonna change that part of the TOPA issue. You know, they're gonna revise that, because it's saying that we do have TOPA rights. And there's some, and there, but
Yeah.
the gist,
Let me just say what you said, not to interrupt your question. So if you have a question coming after that, that's great. But what Ms. Leftwich is talking about is that she sent an email to OTA asking about it was, Bizzuto was the property.
actually it was Avenue 5, Zulu lost the contract.
Oh, well, we've received it.
Thank you so much.
You really don't want to know my
asking-
stuff behind there.
Asking whether something called a notice of change in applicability of law, which is a phrase from the law, from the Rental Act, was accurate. And the notice said this building is now exempt from TOPA. Tenants, paraphrasing,
Right.
tenants don't have any TOPA rights
Right, that's
under
what
the
it's
TOPA
saying.
law. Not true, because in order to get the benefit of that, they didn't even, I'm not sure they mentioned the 15-year.
They did,
basis,
that's part of the problem.
but they mentioned 20B. 20B is the 15-year rule as well.
20B,
There's a couple different notices in play. It might have said different things. But in order to benefit from the 15-year new construction exemption, landlord must have sent a notice of transfer to the tenants. So that is a TOPA right. A notice of transfer tells the tenants what the basis for the exemption is and what their rights are in terms of challenging that declaration essentially by the seller that the tenants don't have TOPA rights because that transfer doesn't trigger a sale.
but is that referenced in this? And I don't think that's transfer of
That's what I'm
rights.
saying.
not.
Your
It's not
notice-
there.
It's
your
not there.
notice-
That's what he said he felt.
And we wrote to DHCD,
Yeah.
once we received your notice, informing them that the notice was insufficient, legally insufficient.
Yes.
We asked them who on their staff, in light of the absence of the administrative capacity at this time, they would like our tenants to submit their questions. We have not heard back from DHCD as of this meeting to that question. So we know that there is a problem, and your property is probably only one of a number of properties that has received the notice, because we are aware that they have been sending out notices to ensure tenants were made aware that their TOPA rights had been voided. So we are working on this issue right now because we already see at the beginning of the process that the communication is erroneous. It's not a problem.
Right. I mean, the only thing I can suggest is to take an exception. I mean, right now I'm not on a lease. I'm not worried about that. I'm not really worried about not being on a lease because I pay my rent every month. But at the same time, I feel as though that we should be able to negotiate something since the Bill of Rights is going to be changed by the end of the fiscal year, correct?
That's right.
DC, but then you have this clause here under their lease, which you sent to the Department of Housing and Community Development. Is that what you sent?
Yes.
So we're waiting on them as well.
We're talking to them about the notice that they sent out. Yes.
I think there's rulemaking in the statute. So presumably, there are regulations on TOPA.
They'd have to be amended though,
issuance
Joel.
of regulations is done by Department Version and Sale Division of DHCD. So there should be rulemaking on all of this. So about the tenant bill of rights, because there's so much detail in so many of the different provisions, not to mention just the rental act regarding
Right,
evictions.
right.
TOPA, we're not gonna be able to fit into everything into the 4 pages that our chief tenant advocate has said. We've got to make this comprehensive and manageable. So we're not going to fit all those details in there.
Let that not be the reason we don't get it done.
Yes, exactly.
Well, that's an inside discussion that we will
Well,
not
no, no,
have
no,
now.
Yes, but let me, no, but the point is that what we'll have, what's new about the TBR is that we're gonna have at least one link, or maybe more than one link in the
One what?
document.
You say link?
A link, just a web link, which gets the reader of the TBR to our website to expand on
new laws that are coming up that are, potentially in the next revision. Number one, or number two, just providing more detailed information than we can fit on the TBR. So you raised a great issue. We really.
Yeah, it's still,
that
it's
was
still, it's just, it's overwhelming because, like I say, I'm dealing with a property management team that's the non-responsive. You know, I'm used to them putting their attorneys on me and all that, and I'm not hearing anything. And I was hoping, now, I've heard some good information today, but at the same time, nothing has been resolved with the, and I get it too, they're probably just as confused as I am because they're new to DC
New for everybody.
property management.
I'm gonna say one more thing about this, which is that it was pointed out that there's a provision in the rental act
Time is-
that landlords are not necessarily going to be liable if they don't provide a certain something to the tenants that the rental act says, requires them to do. That applies to the change in the notice of applicability. It does not apply to the notice of transfer. Tenants still have that right to the notice of transfer, or the exemption
Okay,
doesn't.
so that's the operative.
That's, yes, yeah,
Okay.
that is absolutely operative. I think Cristobal is signs, body languaging me out.
We want to thank our guest speakers for short notice and showing up today. I really do appreciate it. Please. Both of you left. Thank you so much. Thank you so much. This concludes our meeting for today. We will be sending out a notice on our next meetings. We want to make certain that if you have issues that you would like us to raise or do research on in preparation for the stakeholders meeting, please let us know. And we look forward to seeing you again.